This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about criminal conduct by an insured and exclusions that even involve an innocent co-insured. On October 14, 2019, while Safeway Insurance Company's policy was in full force and effect, Mr. Moon, a permissive driver, backed the vehicle into a police vehicle while attempting to flee from the police. In Kristen Moon versus Safeway, a December 6, 2022 decision of the Court of Appeals of Louisiana, the court dealt with the following facts. Safeway issued an automobile policy to Mrs. Moon covering a vehicle that she personally owned. Mrs. Moon's husband, Herbert Moon, was listed on the policy as a permissive driver. The following day, the police informed Ms. Moon that her husband had been arrested and that the vehicle had been towed. Thereafter, Ms. Moon filed a claim with Safeway for the property damages to the vehicle that occurred as a result of the incident. Safeway, logically, denied Ms. Moon's claim based on the criminal and intentional acts exclusion in its policy. Following Safeway's denial of her claim, Ms. Moon sued Safeway. Ms. Moon prayed for not only property damages, but also penalties for bad faith refusal to pay her claim. After answering the suit, Safeway filed a summary judgment motion based on the exclusions. Safeway supported its summary judgment motion with an affidavit from its representative and a copy of the deposition of the investigating officer. Attached to Ms. Marshall, the representative's affidavit, was a certified copy of Safeway's policy. The criminal charges included aggravated criminal damage to property, a violation of the Louisiana statute against striking a police vehicle intentionally. Discussing the law, the Louisiana Supreme Court of Appeal noted that whether an insurance policy provides for or precludes coverage is a matter of law and is an issue that can be resolved within the framework of a summary judgment motion. In answering insurance policy analysis requirements, the court set forth the legal principles that applied. Now, the policy itself, the policy language, provided that the policy does not apply to, among other things, the following, quote, to damage intended by, or which may reasonably be expected to result from the intentional or criminal acts or omissions of any insured person or any other person residing with the insured at the time of the loss. This exclusion applies even if one such insured person lacks the mental capacity to govern his or her own conduct. 2, such damage is of a different kind or degree than intended or reasonably expected. Or 3, such damage is sustained by a different person than intended or reasonably expected. This exclusion applies regardless of whether or not such insured person is actually charged with or convicted of a crime. To damage arising out of the ownership, maintenance, or use of any automobile while being operated or used in the preparation to commit a crime, commission of a crime, and or flight from a crime other than a traffic violation, regardless of whether or not such insured person is actually charged with or convicted of a crime, close quote. The court noted that the incident was the result of Mr. Moon's act of backing the vehicle into a police vehicle in an attempt to flee from the police. Mr. Moon's act was both criminal and intentional. Since Mr. Moon was listed on the policy as a permissive driver and he was a resident of the household. The exclusions, as Safeway contended, apply regardless of who was operating the vehicle when it was being used in the commission of a crime or to flee from the police. Ms. Moon's damage claim arises out of her ownership of the vehicle. Her claim was solely for property damage. The exclusions, as applied, are clear and unambiguous, and the applicability of the exclusions to the facts on which the suit was based, the incident, is not in dispute. Rather, Ms. Moon's contention is that the exclusions are contrary to public policy and for that reason should not be enforced because she was innocent and had nothing to do with the criminal conduct of Mr. Moon. Ms. Moon contends the state's jurisprudence has recognized a policy against excluding coverage for an innocent insured who acts in good faith. And she was clearly innocent. She wasn't in the car. She had no idea what Mr. Moon was doing. Although coverage exclusions generally do not comport with the policy of granting protection for injured persons, the exclusions here serve a separate public policy interest of prohibiting persons from insuring themselves against their own intentional or criminal acts. Withholding insurance coverage for intentional or criminal acts helps to disincentivize such conduct, which in turn serves the purpose of eliminating reckless and irresponsible drivers from the highways. The exclusion is designed to prevent an insured from acting wrongfully with the security of knowing that his insurance company will pay the piper for the damages. The purpose of the exclusion is a recognition of a long-standing public policy against insuring illegal activities and thus promoting their commission. Mr. Moon was a permissive user of the vehicle that he was driving during the commission of a crime. The Court of Appeal found the exclusions were clear and unambiguous and enforceable, and that the exclusions did not violate public policy. In my opinion, the Court of Appeals dealt with the state's public policy of not depriving an innocent co-insured of the right to recover for acts of a criminal co-insured, and the public policy refusing to allow a person to insure against his or her criminal conduct. Finding that the public policy against encouraging criminal conduct trumps the policy of protecting the innocent co-insured, the Court of Appeal ruled in favor of the insurer. Mr. Moon's conduct was clearly intentional and criminal and should not be encouraged by allowing his spouse to collect for the damage he caused to their vehicle. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog and reads this and the more than 4,400 other blog postings. You can subscribe to the blog and will be advised by email that never is sold or used by anyone else about every new blog posting, which will usually be at least 5 a week. And you might also wish to subscribe to the video at rumble.com or at youtube.com so that you can watch or listen to the videos or to the podcast, which is a recording of the video. Please, if you found this video to be interesting or useful to you, tell your colleagues and friends so that they can also subscribe and become subscribers and followers of the blog and the videos. Thank you for your attention.